Despite his refusal to admit it, President Trump's time in the White House is coming to an end, and that puts the issue of presidential pardons front and center. This afternoon, we are getting to reporting on how the president might use this power on the way out, whether he might actually try to pardon himself. Evan Perez has a scoop for us on this. And so what do you know about what the president could be thinking here?
Well, Brooke, first, the president has to move to the acceptance part of his
right.
grief. He's got to work that out. But once he does, I mean, we were told that he's already had conversations with people close to him, some of his aides, to look into this question of exactly how much of these pardons he can do. Now, the easy part for him is that he already has talked a lot on Twitter about some of the people who were involved in the Mueller investigation, people in his campaign who he believes were unfairly targeted simply because they were with him. And those people, of course, include Michael Flynn, his first national security advisor, who's still in court trying to get out of his conviction, or rather his guilty plea, Paul Manafort, his former campaign chairman, and of course, the big question is, what does he do about his family and himself? Now, that's a big question. The president on Twitter mused about this issue in 2018. He said that he believes he has the power to self-pardon. I'll tell you that the Justice Department looked at this question back in the Richard Nixon era in 1974.
Okay, so something absolutely explosive just happened in a federal courtroom that has legal experts calling this the most shocking revelation in American legal history. And the political and constitutional implications are so massive that they're going to reshape everything we thought we knew about presidential power, the pardon authority, and the rule of law in America. We're talking about a federal judge presiding over one of Trump's many legal cases who just revealed, with documentation, that Trump secretly drafted and attempted to execute a self-pardon before leaving office at the end of his first term, and then tried to keep it hidden for years. This isn't speculation, this isn't rumor, this isn't anonymous sources. This is a federal judge presenting sealed documents in open court showing that Trump and his legal team prepared a presidential pardon for Donald J. Trump, signed by Donald J. Trump as president, attempting to grant himself immunity from all federal crimes that he may have committed during his presidency. And when this evidence was presented, the courtroom absolutely erupted. Lawyers were shouting, reporters were running for the exits to file stories, Trump's own attorneys were visibly panicking, and legal observers in the gallery were describing the scene as unlike anything they've ever witnessed in an American courtroom. Because here's what this means. If Trump actually attempted to pardon himself, and if that document is legally valid, or if he believes it's legally valid, it suggests he knew he had committed crimes, it suggests he was trying to place himself above the law, and it opens up a constitutional crisis about whether a president can essentially make himself immune from prosecution for anything he did while in office. Now, before we get into the specifics of what the judge revealed and what these documents actually say, let's talk about why you're probably not getting the full story from mainstream media. They're covering this, obviously, because it's too big to ignore, but they're doing what they always do with Trump legal stories. They're giving you the dramatic courtroom moment, showing you the shocked reactions, maybe playing some audio from the hearing, but they're not explaining what a self-pardon actually means legally. They're not connecting this to the broader pattern of Trump's behavior around presidential power.
And they're definitely not telling you about the legal and political strategies that are being deployed right now by all sides in response to this revelation. And you can't really trust mainstream media anymore to give you that kind of depth and context. That's why we built this channel, to bring you real stories with real analysis, no corporate filter, no political spin. Just the facts and the implications that matter to your life and to the future of this country. We break down complex legal and political stories in ways that make sense. We connect the dots that other outlets miss, and we give you the information you need to understand what's really happening in American politics and law. If you want to stay ahead of the headlines and truly understand the stories that are reshaping our democracy, make sure you subscribe to the channel right now. We bring you in-depth analysis every single day on the political and legal developments that affect your rights, your freedom, and your future. Just hit that subscribe button below to join our community of informed citizens. And if you believe in supporting independent journalism that holds power accountable and tells the truth even when it's uncomfortable or controversial, this is your moment. Subscribe now and be part of the solution. All right, let's get back to what just went down in that courtroom. Here's what happened. Trump is currently facing federal charges related to his handling of classified documents, his efforts to overturn the 2020 election, and various other potential crimes that occurred during and after his presidency. One of those cases is being heard in federal district court in Washington, D.C., and the presiding judge is a highly respected jurist who is appointed by a Republican president who has a reputation for being fair but strict about legal procedures and who has already shown a willingness to push back against delay tactics from Trump's legal team. During a hearing yesterday on whether certain evidence should be admitted at trial, prosecutors from the Department of Justice presented a motion arguing that Trump's state of mind and his knowledge that he was potentially committing crimes is relevant to the charges. As part of that motion, DOJ attorneys referenced sealed documents that they said demonstrated Trump's awareness of criminal liability. Trump's lawyers immediately objected, arguing that these documents were protected by executive privilege, attorney-client privilege, and presidential communications privilege.
But the judge reviewed the documents in chambers and made a ruling that absolutely stunned everyone in the courtroom. The judge said that the documents in question were not protected by privilege because they related to potentially criminal conduct, and under the crime-fraud exception to attorney-client privilege, communications in furtherance of a crime are not protected. And then the judge went further. The judge said that in the interest of transparency and public accountability, portions of these documents would be unsealed and described in open court because the American people have a right to know that their former president attempted to place himself above the law through a self-pardon. What the judge then revealed was that among the documents seized by federal investigators were drafts, emails, and memos showing that in the final weeks of Trump's first term, between the January 6th insurrection and Inauguration Day, Trump directed his White House lawyers to prepare a presidential pardon that would apply to Donald J. Trump himself. The judge read excerpts from these documents in court. One email from a White House lawyer to Trump included language for a potential self-pardon that said something like, "I, Donald J. Trump, President of the United States, hereby grant a full and unconditional pardon to Donald J. Trump for any and all offenses against the United States which he has committed or may have committed or taken part in during his term as President of the United States." Another document was an internal memo from White House counsel's office analyzing whether a self-pardon would be legally valid, with different lawyers reaching different conclusions. Some lawyers apparently advised that a self-pardon would likely be ruled unconstitutional by courts, while others argued there was no explicit constitutional prohibition and therefore it might stand. And most explosively, the judge revealed that there is evidence suggesting Trump actually signed a self-pardon document on or around January 19th, 2021, the day before Joe Biden's inauguration, and that he instructed his lawyers to keep it secret and only reveal it if he was ever indicted for federal crimes. When this information came out in court, the reaction was immediate and chaotic. According to reporters who were present, Trump's lead attorney jumped to his feet and started objecting loudly, saying that the judge was violating attorney-client privilege and releasing information that was supposed to remain sealed.
The judge shut him down, explaining again that the crime-fraud exception applied and that communications in furtherance of obstructing justice are not privileged. Prosecutors looked absolutely vindicated because this revelation supports their theory that Trump knew he had committed crimes and was trying to protect himself from accountability. Other lawyers in the courtroom who represent various parties in Trump's legal cases were furiously taking notes, clearly recognizing that this changes the entire legal landscape. Reporters were literally running out of the courtroom to call their editors and file breaking news alerts, and legal experts who were observing the proceedings started tweeting and going on cable news within minutes, saying that this is one of the most significant moments in American legal history because it reveals a president attempting to use the pardon power to place himself above the law in a way that goes far beyond anything previous presidents have ever attempted. The immediate fallout has been massive. The Department of Justice issued a statement saying that the revelation of Trump's self-pardon attempt confirms the department's belief that Mr. Trump was acutely aware of his criminal exposure and took extraordinary steps to shield himself from accountability.
They also said that they would be filing additional motions based on this new information and that it strengthens their case significantly. Trump's legal team released a statement trying to spin this, claiming that exploring the legal boundaries of presidential power is not a crime and that Trump was simply exercising his constitutional authority as president. They said the self-pardon was never officially issued, was never filed with any court or government office, and therefore has no legal effect. But that defense is already falling apart because the evidence suggests Trump intended to use the self-pardon if he was ever charged, which means he was trying to create a secret legal shield that he could deploy to escape prosecution. Trump himself went on social media and posted what many are calling one of his most unhinged rants ever, claiming that the judge is corrupt, that the whole proceeding is a witch hunt, that every president has the right to pardon himself, and that if he had actually issued the self-pardon, he would have been completely within his constitutional rights to do so. That post is now being used by prosecutors as additional evidence.
Now let's talk about the constitutional and legal framework here, because this is absolutely crucial to understanding why a self-pardon is so problematic and why this revelation is such a big deal. The pardon power is granted to the president by Article 2, Section 2 of the Constitution, which says that the president shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. That's it. That's all the Constitution says about pardons. The language is broad, and historically presidents have used the pardon power very expansively. They can pardon before charges are filed, as Gerald Ford did when he pardoned Richard Nixon. They can pardon large groups of people, as Jimmy Carter did when he pardoned Vietnam War draft dodgers. They can pardon family members and political allies, as Trump did during his first term when he pardoned associates like Roger Stone and Paul Manafort. The pardon power is almost unlimited in scope, and courts have generally been very reluctant to question presidential pardons because it's considered a core executive power. But there's a massive exception that legal scholars have debated for centuries, which is whether a president can pardon himself. The Constitution doesn't explicitly say a president can't pardon himself, but it also doesn't say he can. And there are several legal principles and constitutional doctrines that strongly suggest a self-pardon would be invalid. First, there's a basic principle of law that dates back to English common law and even Roman law, which is that no one can be a judge in their own case. The Latin phrase is nemo judex in causa sua, which means no one should be a judge in their own case. A pardon is essentially a judicial act where the executive is exercising mercy and overriding a legal judgment. If a president can pardon himself, he's acting as judge in his own case, which violates this fundamental principle. Second, the structure of the Constitution suggests that self-pardons are not allowed. The framers had just fought a war against a king who claimed to be above the law. The entire point of the Constitution was to create a system where no one, not even the chief executive, is above the law. If a president can pardon himself for any federal crime, then the president is effectively above the law, which contradicts the basic principle of Republican government. Third, the impeachment exception in the pardon clause suggests that the framers did contemplate limits.
Fourth, the Justice Department's Office of Legal Counsel, which provides legal advice to the executive branch, issued a memo in 1974 during the Watergate crisis that concluded a self-pardon would be unconstitutional. The memo said, under the fundamental rule that no one may be a judge in his own case, the president cannot pardon himself. That memo was written by lawyers working for President Nixon, so it wasn't some partisan attack. It was a legal analysis by the president's own lawyers telling him he couldn't pardon himself. Now, OLC opinions aren't binding on courts, but they carry significant weight as considered legal analysis from expert government lawyers. Fifth, if self-pardons were allowed, it would create absolutely insane incentives for presidential behavior. A president could commit any federal crime, knowing that he could simply pardon himself before leaving office. He could order assassinations, take bribes, commit treason, obstruct justice, anything, and then give himself immunity. That would fundamentally transform the presidency from a position of limited constitutional power into an elective dictatorship with no legal accountability during the term of office. That can't possibly be what the Constitution intends. But despite all these arguments against self-pardons, the Constitution doesn't explicitly prohibit them, and the Supreme Court has never ruled on the question, because no president has ever actually attempted to pardon himself before now. Nixon thought about it, according to historical records, but his own lawyers told him it would be unconstitutional, and he resigned before testing the issue. So we're in completely unprecedented territory. If Trump actually signed a self-pardon, and if he tries to use it as a defense in his criminal cases, courts are going to have to rule on whether self-pardons are constitutionally valid. And depending on how that goes, we could end up with a situation where the Supreme Court has to decide whether Trump can make himself immune from federal prosecution for crimes he committed as president. That's a constitutional crisis of the highest order, because it goes to the very heart of whether America is a nation of laws or whether the president is essentially a temporary monarch who can place himself above legal accountability. Okay, let's break down what this actually means and why the implications are so profound across multiple dimensions. First, understand that this revelation completely changes the legal strategy in all of Trump's criminal cases. Prosecutors can now argue that Trump's attempt to pardon himself is evidence of consciousness of guilt. In criminal law, when a defendant takes actions to hide evidence, destroy documents, or otherwise obstruct an investigation, that can be used as evidence that they knew they had committed crimes. A self-pardon is arguably the ultimate form of obstruction because you're trying to make yourself immune from prosecution entirely. So prosecutors are going to use this in court to argue that Trump knew he had committed federal crimes and was trying to create a secret legal shield to protect himself. That's devastating to Trump's defense, which has consistently been that he did nothing wrong, that his actions were legal, and that he's the victim of political persecution. How do you maintain innocence when you've drafted a pardon for yourself? It completely undermines the defense narrative. Second, this creates massive political problems for Trump heading into 2024 and beyond. Trump's entire brand is based on being a fighter, being strong, being someone who doesn't back down. But attempting to secretly pardon yourself makes you look guilty, weak, and desperate. It's not the action of someone who believes they did nothing wrong. It's the action of someone who knows they committed crimes and is trying to escape accountability through a legal loophole. Trump's political opponents are going to hammer this relentlessly. Democrats are already running ads with headlines like, "Trump tried to pardon himself. What was he hiding?" Republicans who might have supported Trump are now facing questions about whether they're comfortable backing someone who tried to place himself above the law. And independent voters, who are crucial in presidential elections, are likely to be deeply troubled by the idea that Trump believed he needed to pardon himself for crimes he committed while in office. Polling is going to be crucial here, but early indications that this revelation is damaging Trump's support, even among some Republicans who had been willing to overlook his other legal problems. Third, this puts the Supreme Court in an absolutely impossible position if Trump tries to use the self-pardon as a legal defense. The current Supreme Court has a conservative majority, including 3 justices that Trump himself appointed. If Trump claims that his self-pardon makes him immune from federal prosecution, and if that case reaches the Supreme Court, those justices are going to have to decide whether to uphold constitutional principles and rule against Trump. If they rule that self-pardons are valid, they're essentially saying presidents are above the law, which would be a radical departure from centuries of Anglo-American legal tradition. But if they rule that self-pardons are invalid, they're opening Trump up to criminal prosecution and conviction, which will enrage Trump supporters who will see it as the court betraying the president who appointed them. Chief Justice Roberts has shown that he cares deeply about the court's legitimacy and doesn't want it to be seen as a partisan institution. This case would force him to choose between upholding basic legal principles and potentially destroying Trump, or creating a new legal rule that many would see as corruption of the constitutional system. Fourth, this has huge implications for executive power more broadly, far beyond just Trump's personal legal situation. If courts rule that self-pardons are valid, every future president will have an incentive to commit crimes and then pardon themselves before leaving office. We would essentially be creating a system where the president is unaccountable to federal criminal law during their term. That would be a fundamental transformation of American government. The president would have more legal protection than a king, because at least in the UK system, there are parliamentary mechanisms for removing a prime minister. But a U.S. president who can pardon himself is essentially immune from accountability except through impeachment, and we've seen how difficult it is to actually convict a president in an impeachment trial.
On the other hand, if courts rule that self-pardons are invalid, that establishes a clear limit on presidential power in a way that could actually strengthen the rule of law. It would confirm that presidents are not above the law, that there are actions they cannot take to shield themselves from accountability, and that the constitutional system has built-in protections against executive tyranny. Fifth, the international ramifications of this are significant for America's standing in the world and our ability to promote democratic values globally. The United States has spent decades lecturing other countries about the rule of law, about accountability for leaders, about not allowing presidents to place themselves above legal systems. We've tied foreign aid and trade deals to commitments to fight corruption and hold leaders accountable under law. We've sanctioned countries where leaders have given themselves immunity from prosecution. And now we have a former American president who tried to pardon himself.